This is me, Associate Peters. I'm right here in Enugu for a meeting with the Biafrans, and so many important things were discussed. But one of the most important discussion of the meeting is the presentation by Barrister Emeka Emekesri, who flew down from London to file another suit against Federal Republic of Nigeria and Attorney General of the Federation, Gowon and Olusegun Obasanjo. And before I bring him on board, I want you to hear from him the bundle of that case and what that case is all about, and I'll be right back.
Now, the originating summons, let me just read out. We are praying, there are 17 prayers. 17, let me see. 11 and 17 prayers. I think I should read out these ones. Okay. It says, originating summons. Let the it is between IPOB, customary government of indigenous people of Biafra, as claimant, plaintiff, and 1. Federal Republic of Nigeria, Attorney General of the Federation, General Olusegun Obasanjo, General Yakubu Gowon. Originating summons. Let the Federal Republic of Nigeria, Attorney General of the Federation, General Olusegun Obasanjo, and General Yakubu Gowon, within 30 days after service of this summons on them, inclusive of the day of such service, cause an appearance to be entered for them into this summons, which is issued upon the application of IPOB trading as customary government of indigenous people of Biafra, seeking in the interest of its members for the determination of some questions of law, and to compel the defendants to perform their statutory and contractual duties owed to claimants and its members who are agitating for the independence of Biafra, pursuant to the direction and or instruction and or promise given to them by the President of the Federal Republic of Nigeria, President Muhammadu Buhari, on the Al Jazeera television on about the 5th day of March 2016, and pursuant to the provisions of Article 19 to 25 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, Cap N9, Laws of the Federation of Nigeria 2004, which also Cap 10, Laws of the Federation of Nigeria 1990, and to redress all wrongs occasioned on them by the defendants, in consequence whereof the claimants prays for the determination of the following questions. 1. Whether the direction and or instruction and or promise given to members of the claimant by the President of the Federal Republic of Nigeria, President Muhammadu Buhari, on or about the 5th day of March 2016, on the Al Jazeera television, attached herewith as a video record in a flash drive marked Exhibit BF01, that they should organize themselves and vote to have a state within a state, which they have accepted and complied with, by organizing themselves as directed by the President of the Federal Republic of Nigeria, has created an obligation on the defendants from which the defendants can no longer withdraw. 2. Whether by the direction or instruction of the defendants, which the members of the claimant have accepted and complied with as aforesaid, they now have the right to conduct their referendum and vote to have their state of Biafra as a self-governing autonomous region within the Nigerian state, just like Scotland governs itself within the United Kingdom of Great Britain. 3. Whether, notwithstanding and in the absence of any directions, instructions, promises, or offers from the defendants, the members of the claimant have the legal and inalienable right to self-determination pursuant to Articles 19 to 25 of the African Charter on Human and People's Rights, Ratification and Enforcement Act, Cap N9, Laws of the Federation of Nigeria 2004, being Cap 10 LFN 1990. 4. Whether it is an offense and unlawful, contrary to any provisions of the Constitution of the Federal Republic of Nigeria 1999, or any law whatsoever, for the remnants of the Biafrans who survived the war with their descendants to identify themselves as Biafrans by indigenous identity and display their native flags and emblems and Biafran trademarks on their properties and products as they do now, whilst remaining loyal to the government of the Federal Republic of Nigeria as Nigerian citizens. And whether it is lawful for the defendants to harass, molest, arrest, and detain members of the claimant for identifying themselves as Biafrans with their native emblems. 5. Whether the amalgamation of the members of the claimant with the peoples of other ethnic nationalities in the south and north by the British government to form one country called Nigeria was with the consent and agreement of the indigenous peoples of the lands. And if the answer is in the negative, whether the order in council 1910 to 1913 made by the British government to create Nigeria in 1914 was null and void ab initio for lacking legitimacy, as it could not form the basis of the Nigerian constitution, thereby rendering the amalgamation invalid. 6. Whether by the Constitution of the Federal Republic of Nigeria in 1963, which took effect on 1st October 1963, and continued in force until the midnight of 30th September 1979, the defendants were right to seize and confiscate the assets, properties, money, and all treasures belonging to members of the claimant by promulgating the Abandoned Properties Act of 28 September 1979, while the 1963 Constitution was still in force, being more than 9 years after the war and after declaration of one Nigeria, while regarding members of the claimant as Nigerian citizens, but depriving them of their properties, money, and assets. And if the answer is in the negative, whether the defendants are still justified to withhold the said money, properties, and assets belonging to the members of the claimant up to today. Number 7, whether the defendants were justified to violate the international humanitarian law and the laws of war known as the Geneva Convention 1949, to which the defendants acceded to and ratified on 20 June 1961, by bombing the Biafran civilians, killing the Biafran civilians, and using starvation to kill the children, women, and elderly of the civilian population of the indigenous people of Biafra in the war of 1967 to 1970 in order to win the war. 8. Whether the right of self-determination provided under Article 20 of the African Charter on Human and People's Rights Ratification Act supersedes and overrides the provisions of Sections 1 and 2 of the Constitution of the Federal Republic of Nigeria pursuant to the judicial authority in the case of IGP versus ANPP 2007, 18 Nigeria Weekly Law Report, Part 1066, 477, page 457 at page 500, paragraph B to C. 9. Whether it is lawful for the defendants to marginalize, persecute, and discriminate against claimants' region of the southeast and south-south of Nigeria by refusing to develop their region, refusing to revamp their seaports, refusing to dredge their River Niger and other inland rivers to the sea, and threatening to shut down or downgrade their international airport at Enugu. 10. Whether it is lawful for the defendants to acquire a radio license and set up a radio station for the Fulani herdsmen and pay them or offer to pay them the sum of 100 billion naira without doing the same thing for members of the claimant who are also Nigerian citizens. And if the answer is in the negative or affirmative, whether the defendants act in acquiring the said radio station for the Fulani herdsmen and paying them or offering to pay them the sum of 100 billion naira without according the same favor or privilege to members of the claimant being equal citizens of the same country, constitute a violation of Section 42(1)(b) of the Constitution of the Federal Republic of Nigeria 1999 and therefore unlawful. 11. Whether the defendants, by registering Nigeria as a member of the Organization of Islamic Countries, OIC, in 1986, and licensing an Islamic Sharia bank in Nigeria under the 1999 Constitution, contrary to Section 10 of the Constitution of Nigeria, have violated the Constitution and turned Nigeria into an Islamic country. And if the answer is in the affirmative, whether the members of the claimant have the right to dissociate themselves from the defendants and refuse to be called citizens of an Islamic country in the exercise of their right to freedom of worship, freedom of association, and self-determination as a people. These are 11 issues for determination. And now there are 17 prayers. And the 17 prayers are, 1, we are praying the court for an order declaring that the direction and or instruction and or promise given by the President of the Federal Republic of Nigeria, President Muhammadu Buhari, to members of the claimant on the Al Jazeera television on or about the 5th day of March 2016, that they should organize themselves and vote to have a state within a state, which they have accepted and complied with by organizing themselves as directed by the defendants, constitutes an irrevocable promise by the defendants from which they can no longer withdraw. 2, an order declaring that the members of the claimant have the right to conduct their referendum and vote to have their state of Biafra as a self-governing autonomous region within the Nigerian state, just like Scotland governs itself within the Great Britain, pursuant to the direction and or instruction and or promise given to them by the President of the Federal Republic of Nigeria on the Al Jazeera television, which they have accepted and complied with. 3, an order declaring that notwithstanding the direction and or instruction and or promise made by the President of the Federal Republic of Nigeria to members of the claimant, as I've said, they do have the legal right to self-determination pursuant to Articles 19 to 25, Cap N9, Laws of the Federation of Nigeria 2004, being LFN to 1990, and are therefore free to exercise their unquestionable and inalienable right to self-determination, to freely determine their political status and pursue their economic and social development according to the policy they have freely chosen. 4, an order declaring that the remnants of the Biafrans who survived the war with their descendants have the right to identify themselves as Biafrans by indigenous identity and display their native flags and emblems and Biafran trademarks on their products as they do now, while remaining loyal to the government of the Federal Republic of Nigeria as Nigerian citizens. 5, an order restraining the defendants by themselves or their law enforcement agents or proxies from arresting, harassing, intimidating, molesting, or in any other way interfering with the claimant and its members as they display their native flags and emblems and trademarks on their products as they do now, while remaining loyal to the government of the Federal Republic of Nigeria. 6, an order declaring that the amalgamation of the members of the claimant and all the indigenous peoples of the lands by the British government to form a new country in 1914 called Nigeria without the consent of the peoples of the land is null and void ab initio for lacking legitimacy. And therefore the people should be returned to their socio-political condition, status quo ante, prior to the amalgamation, or in the alternative, an order compelling the defendants to convoke a sovereign conference of the ethnic nationalities that make up Nigeria to decide and negotiate freely the terms of their coexistence without the interference of the defendants. 7, an order affirming the memorandum of Ohanes Ndigbo dated 28 June 2012 submitted to the National Assembly for the restructuring of Nigeria into 6 autonomous self-governing regions, namely Southeast, Southwest, South-South, Northeast, Northwest, and North Central, as a manifestation of the will of the people in the exercise of their right to self-determination, and compelling the defendants to present an executive bill to the National Assembly for a law granting autonomy and self-governing status to the 6 geopolitical regions in Nigeria, or in the alternative, in the role of the judiciary as the last hope of the common man, an order directing the defendants to present an executive bill to the National Assembly for a law dissolving Nigeria in peace along the compatible ethnic groups instead of allowing the country to break up in bloodshed. Number 8, an order declaring that the acts of the defendants in seizing and confiscating the assets, properties, money, and all treasures belonging to members of the claimant under its law known as the Abandoned Properties Act of 28 September 1979, being 9 years after the war, and after accepting the people as Nigerian citizens, were unlawful, illegal, and a gross violation of the people's fundamental rights to own properties anywhere in the country. 9. An order declaring that the defendants are liable to pay the members of the claimant by way of compensation or reparation the present value of all their money, properties, assets seized by the defendants pursuant to the Abandoned Properties Act of 1979, in violation of the claimant's right to own properties in any part of the country, since the properties were not seized in wartime, but 9 years after the war, based on the post-war discriminatory policies and laws made by the defendants to suppress members of the claimant from generation to generation. 10. An order declaring that the provisions of the African Charter on Human and People's Rights supersede and override the provisions of the Constitution of the Federal Republic of Nigeria 1999 by the judicial authority in the case of IGP versus ANPP 2007-18 Nigerian Weekly Law Report Part 1066, page 457 at 500 paragraph B to C, on the irrebuttable presumption of law that it is never and can never be the intention of the Nigerian legislator to breach international obligations. 11. An order compelling the defendants to comply with the provisions of Article 23 of the African Charter and consequently give all assistance to the claimant as required by the law, and specifically to do the following things. 1. Sponsor an executive bill in the National Assembly for a law granting claimants the right to conduct their referendum. 2. Set down the timetable for the claimant's referendum. 3. Provide all the necessary logistics for the conduct of the claimant's referendum in the exercise of their right to self-determination. Order 12. An order compelling the defendants to release and unblock the claimant's website at www.ipopgovernment.org and refrain from further violating the human rights of the claimant and its members. 13. An order declaring that it is unlawful for defendants to persecute, marginalize, and discriminate against members of the claimant by refusing to develop their region, refusing to revamp their seaports, refusing to dredge their River Niger and other inland rivers to the sea, and threatening to shut down or downgrade their international airport at Enugu, despite the defendants' promise of the 3 R's: reconstruction, rehabilitation, and the integration since after the war. 14. An order compelling the defendants to embark upon immediate reconstruction and redevelopment of the claimant's region of the Southeast and South-South geopolitical zones of Nigeria, including dredging of the River Niger to the sea, and ensure that their seaports and international airports are of international standard. 15. An order declaring that the defendants act in acquiring a radio station for the Fulani herdsmen and paying them or promising to pay them the sum of 100 billion naira without according the same privileges or favors to members of the claimant being equal citizens of the same country, constitute a violation of Section 42(1)(b) of the Constitution of the Federal Republic of Nigeria 1999 and therefore unlawful. An order cancelling the radio license procured by the defendants for the Fulani herdsmen and compelling the defendants to recover the 100 billion given to the Fulani herdsmen if already given, or refrain from giving the money if not yet given, for being discriminatory against the claimants and other citizens of the country, as the act is contrary to Section 42(1)(b) of the Constitution of the Federal Republic of Nigeria 1999. Order 17. An order declaring that the defendants, by registering Nigeria as a member of Organization of Islamic Country (OIC) and licensing an Islamic Sharia bank under the Constitution of Nigeria 1999, have turned Nigeria into an Islamic country, contrary to Section 10 of the Constitution, and therefore the claimants, being Christians, have the right to dissociate themselves from the defendants and refuse to be called citizens of an Islamic country. That is the 7 orders we're asking for. So we have originating summons. These originating summons, but there's something called interlocutory applications. That is motion. Oh, that is motions. The immediate things to be done while the case is pending. That is called interlocutory application. And they come by way of motion on notice. So there are 6 prayers in motion on notice. That is injunction, mandamus order. We have 6 orders. An order of injunction, restraining the first and second defendants. That is the Federal Republic of Nigeria and Attorney General of the Federation. First and second defendants. An order restraining the first and second defendants by themselves or their law enforcement agents or proxies from arresting, harassing, intimidating, molesting, or in any other way interfering with the claimant and its members as they display their native flags and emblems and trademarks on their products as they do now, while remaining loyal and obedient to the laws of the Federation of Nigeria until the final determination of this case. 2, an order of injunction compelling the first and second defendants to release and unblock the claimant's website at www.ipopgovernment.org and refrain from further violating the human rights of the claimant and its members until final determination of this case. 3, an order of injunction compelling the first and second defendants to cancel and withdraw the radio license and close down the radio station they acquired for the Fulani herdsmen for being discriminatory against members of the claimant and unlawful contrary to Section 42(1)(b) of the Constitution of the Federal Republic of Nigeria, 1999. 4, an order of mandamus compelling the first and second defendants to refrain from giving the sum of 100 billion naira or any sum at all to the Fulani herdsmen as they have promised the Fulani without granting the same privilege to members of the claimant and other ethnic tradesmen for being discriminatory and an abuse of discretionary powers of the executive arm of the government. 5, an order of mandamus compelling the first and second defendants to refrain from shutting down or downgrading the Akani Ibiam International Airport in Enugu, but rather to commence actions immediately and develop the said airport with all facilities to make it functional as an international airport, built and maintained by the first and second defendants to the required international standards. 6, an order of mandamus compelling the first and second defendants to commence actions immediately for the dredging of the river Niger from Lokoja to the sea, and to revamp, develop, equip, and maintain all the seaports and river ports in the southeast and south-south regions of Nigeria, to wit, the Azumini Obak Blue Seaport, the One Seaport, the Calabar Seaport, the Warri Seaport, the Onisha Inland River Port, the Obak Ndoki River Port, and the Uguta Inland River Port. These are 6 prayers under the interlocutory application. These are the prayers that are made by way of injunctions pending the determination of this case. So that is how it is in court. And like I told you, that we are going back to court on Tuesday. And I pray that all of you will be there.
Yeah, hello, Barrister. It's a pleasure. We've had what you've presented at the meeting with respect to the case you filed. I believe this is not the first case you filed against Nigeria. Can you tell us why you filed this particular one and those involved?
Yeah, this particular one is a different case and has different issues and different parties. Yes, it's not the first case I filed in this case, in this issue between Biafra and Nigeria. But the reason we filed this one is because of what happened subsequently. You know, when we were pursuing the first case, when we were asking for whether the people had the right to self-determination, by 2016, the primary question we asked the court to answer, the answer to it was actually given to us by the Nigerian government. When the president of Nigeria, President Muhammad Buhari, now acknowledged that indeed that we have the right to self-determination and gave directions or instructions of what we should do.
They are protesting peacefully for the most part on a regular basis. And there has been video, I could show you some video that's been posted of a very...
No, thank you.
These are the images the President didn't want to see. I'm wondering, how are you planning to deal with this issue of Biafra? You, of course, have first-hand experience.
Put a 30-month civil war, at least 2 million Nigerians were killed. And for somebody to wake up, maybe he wasn't born when there was this fighting in Biafra and said he wants Biafra again. We have multi-party democratic system now. Let them organize themselves and vote for to have a state within a state.
So in that case, we are no longer asking whether we have the right to self-determination, since the government had acknowledged that we have the right to self-determination, but said we should organize ourselves and vote to have our state within the state. In other words, to have our Biafran state within the Nigerian state. Okay. So that means it's a new course of action.
All right. Okay, now the major concern we are having from those watching, those following, the Biafran enthusiasts, is whether or not the Nigerian case or Nigerian court will grant justice to the Biafran people as they have continued to thwart the cause of justice for the Biafrans.
Well, the case may not end in Nigeria. We don't expect it to end in Nigeria. But it is the rule of international law that any people that want independence by the legal method must commence their legal action in the jurisdiction where they live. In other words, you have to start from domestic jurisdiction, being Nigeria in this case. And if Nigeria denies you justice, then you move out from Nigeria to international court. So if they throw away our case, then we move out to international court, such as the ECOWAS Court or International Court of Justice. So whether they accept it or not, whether they give us justice or not, then we don't have any problem. But the way I see it, the president of Nigeria has said, organize yourselves and vote to have a state within a state. And then we have now brought this case to the court to compel him now to put the necessary machineries in place for us to conduct our referendum. Okay. So why will he now say he did not say it? Okay. So let us know let us listen, let us wait to hear what the court will decide on it.
Okay, finally, you have joined some individuals in this case, unlike before. Yes. Why bringing these individuals, and who are they?
Yes, in this case, we have filed now, there are 4 defendants. Federal Republic of Nigeria, Attorney General of the Federation, General Olusegun Obasanjo, and General Yakubu Gowon. These are 4 defendants. You're asking why did we include General Gowon and General Olusegun Obasanjo? Yeah, we did because in the pleadings, inside the suit itself, the roles they played were highlighted. For instance, General Olusegun Obasanjo and General Gowon were those who received the instrument of surrender from the hands of General Effiong. And also, General Obasanjo was the person who signed the Abandoned Property Act of 28 September 1979, 9 years after the war, after the declaration of no victor, no vanquished, after we had the Biafran had been accepted as Nigerian citizens. 9 years after, he signed a law for confiscating all the properties of the people. 9 years after the war. So how is it justifiable? And the federal government, that seized the properties, has continued to withhold those properties up to today. So it's a continuing damage, a continuing course of action. They've continued to withhold the properties, the money, the assets they seized up to today. So he's there, he's still alive. Let him make a defense.
All right. Thank you very much, Barrister. It's a pleasure having you.
It's a pleasure. Thank you.
All right. You have heard it from him. And I think you, the viewers out there, should now make your own submission with respect to all you've heard from the barrister. And as usual, BVI Channel 1 is dedicated to inform you about happenings around the Biafran agitation, to empower the Biafran people with the right information on what is happening within the agitation, the movement for self-determination for the Biafran people. Right here on BVI Channel 1, you all know that we are Igbo-centric and Biafra-centric, and that is why we are discharging this responsibility with all sense of humility and all sense of justice and fairness to the Biafran people, to give them a voice. Now, this is where I'll be wrapping it up on today's presentation, and I'll continue to encourage you to subscribe to BVI Channel 1, continue watching, continue dropping your comment. We are forming a very large community right here. We are not affiliated to any particular group. We remain neutral. We remain neutral to inform Biafra, irrespective of whatever group, as long as you are doing something positive to add value to the agitation of Biafrans. You have a platform, and BVI Channel 1 is your media, a channel for you to air your voice. Thank you for watching. I'll be signing out. Remain blessed and stay safe. Asu Chinedu Peters for BVI Channel 1.